Okay, students, good evening. Tonight I am going to do a lecture on Chapter 15. This is your last chapter of material for this class. Yay for you and yay for me. It means that you've gotten this far in the course. So this is your last chapter. Thankfully, it's honestly usually the one that students understand the most. So it gets a little bit better than it was at the beginning of the term. I hope you find that true and that this material is easier for you. So Chapter 15 is about consumer protection. It's about what laws are out there to help ensure that consumers have the best buying advantage that they possibly can, that they're not being taken for granted, and that products are safe or don't misadvertise in some way that would harm us. So there's only 15 slides for this particular chapter, which also helps, so we should finish up more quickly tonight than other nights. Fraud and innocent misrepresentation. We have talked about fraud in the contract chapter, which was Chapter 6. We talked about it in Chapter 7 that dealt with torts, and we're seeing it again in Chapter 15. So I know that I told you you'd see it 3 times. In 6 chapters, you've seen it 3 times. So you can imagine that places importance on this topic because fraud does seem to be something that we see a lot of in the industry, and that is one reason that people often go to court. So essentially, the required elements of fraud, again, are misrepresentation of the material fact. That has to be an affirmative misrepresentation, so a communicated misrepresentation. The misrepresentation is intentional, and the fraud was relied upon to the extent that someone is going to end up having damages. So it can not only be false expression, so false statements, it can also be false conduct or silence. Let me give you an example of silence. Let's say that I am trying to sell a home. I'm the realtor. I know that there's this huge hole in the floor. I mean a huge hole in the floor, that if someone walked over the floor, they would fall through and hit the ground. So we're going to say that this is a home that's not built on concrete. And I'm from Alabama, and there's still plenty of homes that don't have concrete floors. They're literally up on sort of platform foundations. So let's say that there's a hole in the floor, and you as a realtor slide a rug over this hole, and you place a table over the hole so that no one can literally get over that hole. So it's essentially a barrier. Someone would have to walk around it. So you have intentionally, although you've not said anything, the conduct is certainly there for there to be a misrepresentation, and you were silent. You should have said something, and you did not. So the fact that you did not speak when you should have, because someone was going to rely on this intentional misrepresentation, that is just as bad as if you lied about something. Like the other good example I have for fraud is rolling back the odometer. So there is that material fact, which is a misrepresentation. Someone actually rolled back the dial of the odometer. That it was an intentional misrepresentation because they chose to do that. But it's going to be relied upon when that poor consumer buys that product, and it's, they thought they were going to have a 1,000-mile car, and they have a 100,000-mile car that's worn out. And so, obviously, the damages are going to be that someone is going to get a car that's worth much less than they thought it would be. Okay, and then just to mention, because I'm not sure if it's on the quiz, but there's a difference between, of course, fraud, which is intentional misrepresentation, and innocent misrepresentation, because that is when there's just an unintended falsehood. You say something, but it's false. You may not know that it's false, it may be a mistake, or you may not have meant what you said. So that is not going to be in the same category and not punished in the same way as fraudulent behavior, which is intentionally done to misrepresent. Unconscionable contracts, we did talk about this back in Chapter 6, but that was the 2nd week of class, and we're now in the 6th week of class. So I'm going to reiterate what unconscionable contracts mean, It is a contract which essentially is so unfair or oppressive as to demand intervention by the court. And I told you that it's one of those things that shocks the conscience. The contract itself or some provision of the contract would shock the conscience. It cannot violate societal values, and the relative bargaining power is considered. So the court is going to look at, if you're the one making the contract, did you feel like you had no other choice but to make that contract? And they're going to look to see if the provisions inside that contract are so one-sided that it's just unfair. It's just plain out unfair. There's nothing that can be done other than the court to intervene. So there's procedural unconscionability, which looks at the actual bargaining power of the parties entering the contract to see if it was so unequal that essentially it was not a freely entered into contract. So it's the way that the contract was entered. And secondly, the substantive unconscionability is looking at where there's a clause or the contract itself is literally so one-sided that it's oppressive or unfair to uphold the contract. It sort of shocks the conscience of the court. And so I have an example from, this is another true story from Alabama, about one of those payday loan kind of places that, you know, they're going to hold your paycheck and they're going to cash it later, where they have a 300% interest rate. If you don't pay back within 2 weeks, they essentially give you money up front. They hold that check, at their store, and then they will cash it at a later time. Sometimes this also applies to title pawn places. Excuse me. Go back. Title pawn places where they hold your title, you have title to your car, and then if you don't pay the money back to them, they lend you money. If you don't pay the money back to them, they will actually have the title to your car, come get your car, and sell your car to get the money. So I saw cases where there would be 300% interest on those loans, which is unconscionable because it's impossible to pay that back. If you borrow $100 and then when you go back, you have 3 or 4, even maybe 500, depending on the interest rate, dollars to pay back for the $100 loan, then it's unconscionable because the average consumer wouldn't be able to do that. You would not have gone there in the first place if you needed, if you couldn't pay back $100. So you're certainly going to be able to pay back $500. So it can't violate societal values. Okay. The next law is lemon laws, and this does not involve fruit. This is not about the sale of bad lemons, fruit. This is about cars and automobiles, which we call lemons when they are sort of substantially broken down for a period of time that really leaves you sort of renderless of a vehicle. So all 50 states have some form of lemon law. They're all different. There is one of your homework assignments, I think, this week is to look at some lemon laws and compare them. Ours is actually pretty liberal in Florida. It's more protective than some of the other states, to be honest. So all 50 states have some form of lemon law. And basically the first bullet there is what the major provisions are. So it looks something like this. They may all have a little bit of difference, but it's going to look something like this. Typically, the vehicle must have been returned to the manufacturer or the dealer 3 to 4 times to repair the same defect, and that defect must substantially impair the value or safety of the vehicle. Or you must have been unable to use that car for like 30 days within a 12-month period. Some states say you have to have 30 consecutive days within a 12-month period. Some say 30 days over a 12-month period. So if you went 2 weeks, I had a lemon about 2 years ago. I didn't end up lemon lawing it because I didn't realize how much better the law was here in Florida. But here you might be able to, I'm so sorry. I can't figure out what this is doing. It keeps cutting in and Here, you might be able to have a lot less time to show lemon law than other states, but 30 days does not have to be consecutive here. And the last reading that I saw, okay, I think it's going now. Sorry, guys, was 14 days. And so 2 weeks is not all that difficult to come by if you have sort of a serious defect in the car. But they differ from state to state, and states change these quite often because they see too many lemons coming in at one time, and so they rewrite this a little bit so that not so many lemons would be coming in. But essentially what happens is you've got to have either taken your car to the dealer for the same kind of repair 3 to 4 times, or you have to be out of the ability to use that car for some significant period of time, usually consecutive days in a row. But it could be 14 to 30 days is the average in most of the states. If that happens, and this is for new vehicles, this is not for used vehicles, because when we buy a used vehicle, we sort of take it as is, unless we've got some warranty with it, or it still comes with warranty, or you buy an extended warranty from the dealer. But this particular lemon laws deal with new cars. So if you are sort of found to have the lemon, then you can get either a replacement value, and you can get the money that it would take to get you a new car, so a full refund back from what you paid, or you can get an actual another vehicle, replacement vehicle. The usual determination is going to be done by arbitration in most states, and it does differ from state to state, and states are continually changing these laws because they don't want it to be too unfair to the manufacturers or dealers as well. The Consumer Product Safety Commission, I added this slide in because there is a quiz question on the Consumer Product Safety Commission, and really you just need to know what the three things are that they do. They govern unsafe products. They ban products from the market when they find products that are either unreasonably dangerous or are being unreasonably advertised, which we'll talk about more in a minute. They can ban products from the market. They can mandate product safety testing procedures be done on products, like, for example, car safety testing. And they recall products from the market. When they find out that a particular product is unsafe, they recall that from the market. The Federal Trade Commission Act, the FTC. The Federal Trade Commission was really meant to prevent unfair methods of competition and unfair deceptive acts or practices in and affecting commerce. They also regulate false advertising. So it's meant to take away unfair practices relating to trade, related to commerce. And they also want to regulate false advertising because they should not be able to say that a certain product has fewer calories, or it's fast acting, or lose more weight in one day, or more effective, or more pervasive, if it's really not. They have to be able to prove that. So let's say that there's a specific kind of orange juice that says 50% less sugar than all other orange juices, or 50% less calories than all other orange juices. For them to say that on the label, that has to be true. That has to be verified, documented, supported by doing some actual studies to show that the calories are going to be less and the sugar is going to be less. They cannot say it if it's not verifiable. So fewer calories actually has to mean there are fewer calories. Fast acting actually has to mean that in a scientific test there has been a faster acting product for them to put that on there. So basically what the FTC processes look like are the Federal Trade Commission will put rules out to make sure that products are complying with being fair and being honest about the products. And then if the Federal Trade Commission finds that there are some unfair or deceptive practices out there, they will go through adjudication measures. So they may conduct investigations on their own. They can settle matters informally. They can file lawsuits for you. They could, put you in arbitration or with an administrative law judge to figure that out. And the three things that I have underlined there, I remember specifically are quiz material. So they may conduct investigations, they may issue cease and desist orders, and they may issue industry guides to advise the public. So they can issue cease and desist if they see that that orange juice is saying 50% less sugar, and they're indeed not 50% less sugar. They can issue a cease and desist order to stop that company from allowing them to continue saying that message. And in fact, they can even pull that product from the market until they can get that fixed on those labels. The Food and Drug Administration, this is a really easy one, really does regulate food, including lemons. They are responsible for protecting the public from dangerous food items, from drugs, that means prescription drugs, medical devices, radiation-emitting products, and cosmetics. So they really govern a lot. They're looking at things that we ingest, that we, of course, digest, and things that are chemicals that we would put on our face, which eventually go into our system in some way. So the Food and Drug Administration really is all about trying to protect you from dangerous ingestion or digestion of items. Back when I practiced law, there was an ongoing Vioxx controversy. Vioxx was a prescription medication that people would take, and it ended up causing a lot of heart attacks across the country. At one time, there was about almost 140,000 heart attacks within a very short amount of time related specifically to this drug. So the Federal Drug Administration would pull that from the market, at least temporarily, until they can investigate that further. And if they find that it's true, if they find that there is linkage, then they may pull it altogether. All right, consumer privacy issues. Of course, there is more identity theft today than ever. This is from the old book, so the statistic here is 9.3 million U.S. citizens suffer identity theft in a recent 12-month period. I would say it was probably much higher today. I myself have been a victim of identity theft 3 times since I've lived in Daytona. So we're talking 3 times in 5 years. I do, however, use a credit card a lot. I use a credit card a lot, and I pay it off every month. And the reason that I do that is because if I have one bill with all of the charges shown, I can look at it to see if there's any error. If I use a bunch of different cards, it's a little harder to track what kinds of charges I'm making. And then I just, cut a check at the end of the month to make sure that all of the charges are accurate. It's good because it protects me. There's more protection in a credit card than maybe other types of maybe debit cards that you're using, because debit cards, that the banks have a little more time to refund that money to you. And if it is, if you're using the credit card, the credit is out in credit land, even though there might be a dispute, the money is not actually taken from your bank account like it is from a debit card. So I personally use a credit card. Because I use a credit card so much, I have had 3 issues of identity theft. So, they not only do thieves dive into the dumpster and look for, credit card applications and unfilled out loan applications and things like that. They also go through just your trash on the street. That's why, of course, people recommend that you use a shredder, a really short multi-cut shredder, so that they can't see that information. They go into computer software and hack your computer, and they hack your credit cards. There was a show called The American Underworld. I don't think it was out very long. I actually watched it a few times because I was just shocked. I don't think like that. I'm not a criminal. I've never done any kind of criminal activities. And so I don't think like that. But there was a show, The American Underworld, that showed a person that they're not very expensive, they're credit card reading devices. And so this often happened at restaurants where the server would swipe the credit card and then they would have their own card reader and they would swipe it again. And so the card's getting swiped twice. The card doesn't get charged twice, but they're reading the number and then they are able to go make a fake credit card from this. It's not very expensive to buy that software, and so there was a lot of credit theft because of that. I also found it interesting on one of the shopping shows that I watched at one time recently that said that stores are tracking your coupon usage. So when you make a charge on a credit card and there's been a bunch of coupons attached to that, they're looking to see where you shop and what kinds of coupons you will buy from. That's why often if you buy a certain kind of item, you might get more coupons in the mail like that, or more coupons in your email, even like that. So especially grocery stores, they're going to look to see all the different kinds of products that you buy. They track those coupons and how many come in so that the people who are putting out the products can put more of those coupons out to the general public. So we have a lot of privacy issues, and the more that we're online, the more that we use social media, of course, privacy issues are going to become even more prevalent because people can go online in a very short amount of time on social media websites, find out a lot about you, what kind of movies you like to watch, what kind of music you like to listen to, what kind of products you support, what kinds of web pages you follow, who your friends are, what stuff they like. They can find a lot of information about us in a very short period of time. So there is some concern that if we increase privacy protections online or with credit cards in any regard, that the cost would actually go up to consumers because someone is going to be watchdogging that more, meaning that we have more people to pay in the chain who would be actually sort of watching for this. California is the only state which requires data companies to notify you when records are compromised. So not all states have to notify you right away when your records are compromised. Most credit card companies will. If they see something going on, they're going to call you right away because they don't want to have to go expend a bunch of money either. Usually under credit cards, you're only liable for the first $50 or so, and that's almost usually more when you're negligent with your card, like I left it at the bar and then it got taken. If someone steals your purse and has your credit cards in it, the most you would likely be liable for would be $50, and you may not even be liable for that. So credit card companies have a vested interest in calling you when they see charges on your card. My credit card company, like I said, I've been hit 3 times in 5 years. They called me within about 2 hours because I use it so many times in the day. If I get coffee in the morning, I use it. If I eat lunch, I use it. If I get gas, I use it. So if I have several transactions here in Daytona Beach in one day, and then at some point, like at noon, there was someone using my credit card in Las Vegas, and then an hour later, I used it to get gas here in Daytona. So within an hour, they had stopped my card and called me to figure out, was I in Las Vegas? Obviously not. So they fixed that. So credit card companies do have a vested interest to inform you, but they are not required to do that right away, except in California. Okay, the Truth in Lending Act. This is a lot of stuff on the slide, but really what you need to know is that the Truth in Lending Act just requires a conspicuous disclosure of the amounts financed, the finance charge, the annual percentage rate, and the number of payments. So when you go to buy something today, you are supposed to be told exactly how much that's going to cost. So if it would only cost $100 if you paid cash today, but now you're going to pay credit, and there's a 20% interest rate per year, and it's going to, if you do just the minimum payments, it's going to be this much in the next 5 years to pay it off. They have to tell you all of that now. They have to tell you the amount you're going to pay, the amount you're going to be charged to make that credit payment, the annual percentage rate that you have to pay, and the number of payments it is likely to take you to pay that off if you pay the minimum payment. So they're very careful today now to really let people know how much it's going to cost, because people were putting so much on credit and not understanding how much it actually takes to pay that off. So this applies not only just to your charge cards, but to your loans. So you'll notice in the last few years that your statements probably for your credit cards have gotten even longer than ever, and your statements for your home loan, car loan may look a little different than they did a few years before that, because they are required to be much more explicit in how much debt is going to incur from this charge now. Consumer credit reports. Anyone who has credit, and most every human being is going to have credit other than maybe children, in our country at least, has the right to find out if they are denied credit. They have the right to find out who denied them and what credit reporting agency was used to get that information. So anyone using credit from a credit reporting agency, when there is an adverse reaction, there's an adverse action, they choose not to give you credit, they must notify the consumer that the credit has been denied and disclose the source of the information relied upon. So if I went down to Macy's and tried to take out a credit card and they deny me, then I'm going to get a statement in the mail probably a week to 2 weeks later that says, you were denied because you have too many credit cards. So they have to tell you the reason, and they have to tell you what, and we used Equifax credit agency to make that determination. They have to tell you which credit agency they got the information and why you were denied. They don't have to go into specific detail, but they have to tell you have too much credit, or you have too many credit cards, or you've been in default too many times. They have to tell you why. Once the request is made, the credit reporting agency must give the consumer information filed on them and a list of all those who have recently sought information about the consumer. So they have to not only give you that specific information about why your credit was denied, you can also ask for a list of who all has been accessing my credit, and they have to give you that too. The ones that are in red here, if it's in red, I remember that it might be on the quiz, so I highlighted that in red. The credit reporting agency must investigate any complaints of inaccurate information, any error in their files. So if you tell them, hey, look, I've never been late on a debt. I don't know why this is saying that I'm late. Something is wrong with your record. They have to investigate that. The credit reporting agency themselves have to investigate why there's inaccurate data on your credit report. And all of this comes from the Fair Credit Reporting Act. I'm sorry I didn't mention that earlier. The Fair Credit Reporting Act is where all these provisions come from. All inaccurate information must be corrected or removed within 30 days. Negative information more than 7 years old is generally not used. Bankruptcy typically stays on your file for 7 years. But things that are older than 7 years, bad credit older than 7 years starts to come off most of the time. Consumers must provide written consent before the credit reporting agency can provide your information to the consumer's employer or prospective employers. Consumers can sue for damages, of course, if their rights are violated, if any of these things are violated and they are not cooperative with you. And customers disputing information on their credit report can file their own version of the facts in a brief statement to be placed in the credit file. So if you say, I have never been late, I don't know what this company is talking about, in fact, I've never even had a credit card with this company, you can file your own written statement of the facts, and the credit reporting agency also has to stick that in your file so that the next time someone pulls that information, before they have a chance to correct it, that other company looking at your file would also be able to see what you have written in there. So there's a few other federal credit laws. There's the Fair Credit Billing Act, which just makes sure that It's a mechanism to deal with billing errors that accompany credit card transactions. There's the Electronic Fund Transfer Act, which just really looks at electronic banking problems and lost and stolen cards with billing errors. And then the Equal Credit Opportunity Act, it requires that a credit be extended to all credit-worthy applicants, regardless of your gender, marital status, age, race, color, religion, or national origin. It falls very much in line with Title VII, and it just basically says that, like Title VII, we cannot discriminate against people in lending credit. Anyone who has credit worthiness should be allowed to get credit. Fair Debt Collection Practices Act. This is an important act because it keeps creditors from bullying consumers. The Fair Debt Collection Practices Act is designed to shield debtors from unfair collection tactics by debt collection agencies and attorneys. So it's protecting consumers from debt collection agencies and attorneys. It does not extend to the creditors who are trying to get their money back. This is really only to protect consumers. It forbids the use of obscene language. They cannot yell and cuss and scream and say things that are inappropriate to you. They cannot contact third parties trying to do anything other than to find you. So if they call your neighbor, they cannot say, I am looking for Shanna and she is in a ton of debt and she's in big trouble if she doesn't call us. They can only say, I'm looking for Shanna, your neighbor. Have you seen her in the last 3 months? Or whatever they come up with. But they can only call third parties to locate. They cannot disclose any of the information about your debt situation. They cannot use threats or physical force. They cannot call you during inconvenient hours. So usually, 8 a.m. to 8 p.m. is reasonable, but they should not call beyond that. They cannot call you 1 million times a day with the intent to harass you, that the more phone calls you get, eventually you'll give in. They cannot do that. And of course, if there's any other unfair, abusive, or seemingly deceptive manner, then they will not be allowed to contact you anymore. So this act just really is trying to protect consumers from abuse when it comes to getting their money back. Okay, there are 3 types of bankruptcy. These are the last 3 slides, and we are done with this chapter. Bankruptcy. The Chapter 7 bankruptcy is about liquidation. It is literally about liquidating what you have to get rid of the debt. The debt goes away. You are not on a payment plan. The debt goes away. Of course, bankruptcy does stay on your credit for at least 7 years, but it is literally about getting rid of the debt. In Chapter 7 liquidations, all assets except exemptions are distributed to creditors. So basically, the trustee of the court takes the property, tries to sell it and make money on it, and then pays those creditors off. There are several things that usually are exemptions, like in a bankruptcy, a couple could keep 1 car, they can keep their home as long as they're not in default on the home as well, and some personal property items, some life insurance, and some necessities. But other than that, if there are other assets around the house, if you have a boat that's paid off in your garage and you owe 30 grand, they could use your boat, they could sell your boat to make money to pay these creditors back. So you don't just get to keep everything. There are certain things that you get to keep, and those are called exemptions. But basically what happens is if someone goes in and they really have nothing, and there's nothing to even sell to make money, it gets rid of this debt. It's usually that unliquidated, unsupported kind of debt, like credit card debt, where there is nothing for them to take back because they'd have to take back 1 million things. So there's nothing for them to take back. They're going to make you sell any larger items that you have that you can make money on to pay the creditors. So it is essentially a complete liquidation of that debt. Chapter 11 is a business bankruptcy. It's specific to businesses. It is about a way for businesses to continue business operations while paying off their debt. So it's called a reorganization. The purpose of the Chapter 11 Bankruptcy is to allow financially troubled businesses to continue operation while payment adjustments are arranged. Both debtor and creditors usually benefit from this because the debtor is able to have time to make payments and make payments in a reasonable amount, which are usually much less than whatever credit card amount charges are underway. The payment may even be a lot smaller than the minimum payment on a credit card would be. So typically the debtor can continue to operate the business. And then finally, Chapter 13 is another consumer bankruptcy possibility. And more people than ever are going into Chapter 13 bankruptcy rather than Chapter 7, because if you can make a $100 payment per month, you might qualify for Chapter 13, especially if you have a little bit higher income and you can make that $100 payment a month. The courts are going to try to put you in a Chapter 13 if it's possible because they want you to pay back the debt. They want you to pay back the debt. They just realize you might not be able to pay all of it back, and you might not be able to pay it back in the same ratio and rate of paying back that the credit card company and the other creditors may want you to. So they try to set you up on a plan that you can reasonably pay back over time, but that way some of the debt is paid back. It's not just forgotten like it could be under liquidation. So under Chapter 13, individuals can seek the protection of the court to arrange a debt adjustment plan. More individuals are going into this kind of bankruptcy, and it is restricted to those with steady income, so meaning jobs with steady incomes, and somewhat limited debts. The debtor develops the repayment plan with the creditors where the trustee is helping them do that, and the debtor might even have up to 5 years to make those payments back. So this is the last chapter of material. I do think that students find this material easier. I certainly hope that you did as well when you watch this video. Please do remember that you can call me and ask any questions that you have about material that is confusing to you. The semester has gotten much better as far as homework goes. Students are doing much better by now, as you should be. And so I hope this last week of homework is challenging but fun for you, because it is the last week of actual homework. Next week, for week 7, you will do a legal wrap-up, which students do really enjoy. It's a nice change of pace from the same 3 kind of assignments and a quiz every week. Then you won't have a quiz next week. You'll do the wrap-up, where you can do a PowerPoint or you can do a Word document where you are assuming you are a CEO of a company and you use terms and terminology that you have learned in this semester to do some kind of training for employees in your company. If you are a CEO and you wanted your employees to know more about things that you've learned about contracts or torts, about not going out there and talking on their phone while they're in a company car, because if they get in the accident, it could be related back to you, the employer, if they were in the scope of employment when they had that accident. So things that you've learned that you would want to relay back to your employees, you can either do it in a Word document or a PowerPoint. Directions are up under the content section, and they are under the news section along with some examples. So I think you'll have a lot of fun. Students seem to like that for the last assignment. It certainly makes it easier in finals week not to have a quiz. So I've enjoyed teaching.